So for everyone joining, we're going to start just shortly. We're just waiting for the number of participants to go up, and when I get the signal, we'll start off and I'll introduce everyone. Okay, we're going to make a start. So hello and welcome to this Doughty Street webinar on deportation, new strategies and challenges. I'm Zoe Harper and I'm a barrister in the immigration team at Doughty Street Chambers, and I'll be chairing the webinar today. I'm joined by my colleague Phil Hayward, a barrister in the immigration team also. Phil practices across the full range of immigration and from Chambers and Partners, he's identified as highly regarded for his extensive experience and expertise. And his long-term work on deportation has included success before the Court of Appeal, among other cases. And so I'm really pleased he'll be sharing his insights today. Both Phil and I are absolutely thrilled to also welcome Dr. Luc de Noronha, who is joining us to present on his research. Dr. Luc de Noronha is an academic and lecturer in race, ethnicity and post-colonial studies at University College London. And his recent book, Deporting Black Britons, Portraits of Deportation to Jamaica, is an important ethnography tracing the lives of 4 men brought up in the UK since infancy and subsequently deported to the Caribbean. There's a link to the book in the slide and also an updated link in the seminar invitation on our website. The book is currently half price, so it's an absolute steal if you go direct to the publisher, Manchester University Press, for it. So and you'll see from the rest of the seminar today that we highly recommend it. It's been a really important and thought-provoking book that's had quite an impact on an understanding of our practice. But before getting into the seminar, I'll just give a brief overview of the tech for today and then an outline of the seminar. So everyone present will notice that your microphones are muted and your video cameras are off, and that's just a presetting to stop any background noise interference. But we do, however, welcome discussion, and so very much invite you to use the chat function to raise questions or share comments and perspectives. And you have a choice around sharing questions and comments just to the panel or to the group as a whole, as you prefer. And we'll try and pick up on as many as we can for the recording and as we go along during the seminar, because your insights will be really valuable. We're recording the webinar and a copy will be available on the website soon after we finish for you or any colleagues who couldn't attend today. So the outline for the seminar today, you'll see from the slide, it's very much in 2 halves. Firstly, we're going to invite Dr. Noronha to present on his research and summarise some of his findings for us. And then we'll take some time to discuss some of those themes from the research in more detail with questions and comments. And so do encourage you to put comments and questions in the chat to enable us to pick up on those after Dr. Noronha's presentation. He will probably speak for around 10 or so minutes, and then we'll have a wider discussion for the first half of the seminar. The second half of the seminar, we're going to focus more on the strategies and challenges that the research presents for our practice. So both myself and Phil will talk through some thoughts from a kind of more of a practice perspective based on the research. And so just in terms of today, it's very much not a traditional seminar where we present slides and set out the law and what we think and what the answers are. It's very much intended as the beginning of the conversation, identifying potential areas for pressing the law, gaps where we think that there may be potential for developing the evidence and developing the law. I think when we originally envisaged the seminar, that there was a real sense of optimism, and from a recent line of cases that we'll discuss from the Court of Appeal discussing undue harshness, that's been tempered slightly by the very disappointing decision in Begum by the Supreme Court, not on deportation, but has a sort of tangential a relationship to the discussion. And of course, we've also seen recently the publication of the new immigration plan for consultation before yet another immigration bill, layering on increased hostility. However, despite that, there are such important insights from this piece of research that help us make some of the issues of racial inequality that underpin our work much more visible, to enable us to consider new strategies to address them. And as this is sort of the beginning of a conversation, you know, we very much welcome your insights and perspectives in the chat as we go along. So that's all from me as an outline. I'm going to stop sharing this so you can see everybody more clearly. And I'm now going to introduce Dr. Luke de Noronha to talk about his research, Deporting Black Britons. I found his book really informative and thought-provoking, so I'm really thrilled that he'll share his insights here today. As I explained, he conducted research on 4 young people deported to Jamaica, explores the process of deportation and the impact on the individual, and quite groundbreaking for us, for a researcher to actually have had contact with people after being removed. But also discusses the wider implications of what deportation means and how racial inequality may be entrenched through that process. So without further ado, I will introduce Dr. Noronha, who will now talk about his research.
Thanks so much, Zoe, and thanks for having me. This is an important kind of conversation, I think, to think about the relationship between, you know, academic work, activism, and case law, and, you know, strategic litigation, whatever you want to call it. So firstly, I'll just describe the book. Thanks for the kind introduction to the book. But for those who haven't come across it, it's, as you mentioned, an ethnography based on years of research with people deported to Jamaica primarily. And I suppose one of the questions for whether an academic, activist or journalist is what happens to people post-deportation, and for lawyers, who of course I know many of, and who always, the case kind of ends really mostly when a person is removed. So what happens post-deportation was one of the key questions, but also what do people's whole life stories remembered from Jamaica reveal about Britain, and about the relationship between racism and immigration control and citizenship in particular. So I'll stick with that as a kind of organizing question, which does organize my book to some extent as well, but particularly has a kind of resonance here for thinking about the relationship between racism, racial justice, racial inequality, and immigration control, immigration law. The book's kind of a set of intimate portraits of the 4 guys and a few others who get threaded into some of their chapters, where I try and tell some stories of separation and exile, survival, and hardship, and also how friends and family who remain in the UK narrate these deportation stories and understand these kind of processes of enforced separation. Okay, so the relationship between racism and deportation. If we start with it, on the level of what does racism have to do with who gets deported, we should all know from our experience is, I assuming most people here, solicitors and barristers, but even anyone who works in the migrant sector or anyone who's interested in racial inequality should know that racism in schools and in the criminal justice system, the institutional racism is likely to precipitate deportation, to propel people towards deportation. So it's totally unsurprising. If you're heavily surveyed and policed and more likely to be sentenced and imprisoned, then you're more likely to end up being deported. You can trace that back to racism within schools, school exclusions, the relationship between class and race in the labour market, and then criminal justice for the purposes of deport cases is the obvious and the central kind of factor. And we know from various reports, whether it's the Lamy Review or whether it's the anti-racist groups or whether it's the researchers looking at racism in the criminal justice system, that if you're Black in particular, you're more likely to be more heavily punished at every stage, from stop and search right through to sentencing and to prison, even your treatment in prison. So we can return to some of that in the discussion. I think it's also important to say that I looked at how gendered ideals and stereotypes work with racial classifications and racial stereotypes to make deportation possible. So as we know from deport cases, who is a proper and responsible father, which relationships are genuine and subsisting, whose separation would be unduly harsh, and whose circumstances are very compelling, are all literally the terms on which you have to make arguments. In my work in particular, Black men's reproductive labour and care work was made totally invisible, pretty much, or denigrated totally to justify deportation. So things like, you didn't really cohabit, or you couldn't prove that you were cohabiting, you weren't financially providing for your children, you aren't the biological father of your children, or you have children with two partners, you only have some evidence that you collected your kids from school, for example, and the list goes on. Which shows for me how something like racial discrimination works through ideas about gender, sexuality, and the family. That is through determination over family life. There's a set of stereotypes that play in to the legal process, which might be hard to measure, but which I think would be unwise to say aren't at play. So in many of these cases, all the cases I know of really, and the cases in the book and the cases that I've done legal reports for, well, let's forget about the protection element for now. In many cases, it hinges on public interest versus Article 8. And so in that context, the racialization of Black men and other groups of racialized men too, as both especially dangerous, threatening and violent, supports the public interest case. And then the fact that they're it's deemed to be incapable of being responsible fathers and husbands, partners, works against their claims under Article 8. Which then makes deportation especially likely. So if proportionality is the thing, racism matters for both reducing the importance of Article 8 claims of private and family life and increasing the Home Office's case for public interest, danger, threat, reoffending, all of that stuff. So that's the stuff that resonates with this event. I think, how does racial discrimination feed into deportation proceedings? And can we make that legible, turn it into a factor so that judges have to consider it? I think that's partly what we're going to talk about. We might think about better factoring in the care work of fathers not living with their children. We might make arguments about valuing care work as much as financial providing. We might think about the impacts on children of losing fathers. But again, here we should be very careful not to play into a kind of absent fathers and, a lot of the arguments about the reason that young Black men, for example, end up in the criminal justice system tend to rely on the same arguments that are used in deport cases about irresponsible fathers, absent fathers. So we have to be careful not to play into a particularly short-term racial trope about, this kid might become a gang member if their father's deported. That's not great strategy overall. So that raises a question about whether we'd be better to try and just raise the weighting for family life and for best interest for everyone, rather than, or the tension between just trying to raise the floor for everyone versus a kind of racial equality angle, which might have some trade-offs in some of these cases. And we're not there yet, but I think it is always worth thinking about. My book offers radical arguments, both the form of deep critique for the sake of deep critique, you know, to understand the problem we're up against, to understand how the system works. And I'm not a lawyer, obviously, so that's useful for a book in a way that, of course, a judge won't hear. And then also a kind of, the book may be radical in a sense of political possibility and alternatives with a longer time frame in mind. So, or a further horizon for struggle, which is different to the time frame of litigation. So I recognize that, and I'm not saying that to point score or to say that one is right or the other isn't, but it's important for thinking about why you make the arguments you do and the limits of the different fora in which you make them. So my arguments about family try not just to expand family life, but to explode it, to critique the family through thinking about friendships and relationships to yourself or places, you know. So why would a person, just the problems we have when we have to kind of fit someone into a category about a genuine and subsisting relationship with a partner, but friendships and just relationships to a place can't factor in. And then arguments for me about racism are also not just about finding the discrimination in the system, but thinking about borders themselves as the ultimate signs and motors of a racist world order. So I want to say a little bit about that, about the broader argument I'm trying to make about racism, because I think it's a useful starting point before we then think about how we can make racism maybe relevant in the court and maybe help clients to be able to stay. I think you can do both, but I just wanted to kind of give the overall framework. So the book is not about documenting racial inequities and saying, aha, deportation is bad because Black people are more likely to be deported, as though deportation could somehow be made non-discriminatory. Of course it can't, and it's worth thinking about why it can't. So this is where kind of theorization becomes important. So it depends about what we think racism is. If racism is discrimination based on skin color, which I think is the kind of layperson's definition, then deportation can indeed be discriminatory and we can try to prove it, right? So there's discrimination or disproportionality for people racialized in particular ways. On the basis of skin color or something equally phenotypical, and then we can try and prove it. But who knows exactly what this means for the many Poles, Romanians, and Albanians who are highest among the deport cases probably now. But still, we can prove that discrimination against Black and brown people in the criminal justice system precipitates deportation, and maybe that's useful. However, it can be a bit of a dead end to try to prove discrimination, or at least there are limits to proving discrimination within a system when it is the system itself that is the racist thing that does the racism. So in other words, what I mean by that is, it is the very legal exclusion of people from political membership, the detaining and the deporting, the enforced separation, which constitutes the inherent inescapable racism of immigration controls and citizenship. More broadly, is the carving up of the world into fixed but highly unequal national citizenries, which reproduces the racist world order. And so the history of nation states, with all their inequalities, the history of countries emerges out of centuries of imperial and colonial domination. The history of the modern world, the only history we have, is the history of colonial modernity. So what precedes the post-war, post-colonial world of unequal nation states that we operate in now is the much longer history of European empires. And that means that the bordering of nation states and of regions like Europe, the exclusion of people from Europe, North America, or Australia, obviously perpetuates that explicitly racial history. Race has been the primary system of classifying human difference in the modern world, along with nation, organizing and managing global populations through ideas about their fixed geographic and hereditary difference. I say all that because if we're thinking about racial justice and racial discrimination, I suppose it matters if we truncate that into a thing about discrimination in the immigration system without recognizing that the system itself is race-making, is racist, reproduces a racist world order. So, and you know, that's where theory and history are important to think about race and nation. And I think that's important to think a little bit about what I want to go on to, which is along with, hopefully in complement to good case law, good law, you know, good legal representation, strategic litigation, would be a wider movement for racial justice, which would need good strategic litigation, but which would not be contained by it. So all of this is to say that immigration controls and fixed citizenship regimes, all the legal exclusion, surveillance, disposable and temporary labour, separated families, rightlessness, detention, expulsion, people dying in the deserts and in the seas, all of this, the whole international system of nation states controlled through borders, is racist and makes and remakes a racist world order. So that makes claims about racist discrimination within the system, to me, seem slightly upside down. Because it's not as though the kind of accidental discrimination can be taken out of the system. Actually, the system of illegality, detention, and deportation is what makes racial difference and racial hierarchy, again and again, layering it on top of other kinds of histories of racial violence. So I'll skip some of that. This is not to say anything that anything short of the most radical, most revolutionary arguments are no good, but it is to say that it is to just sketch out how I think racism and borders are related. And so the fight for racial justice must ultimately be about a much broader fight to restrict and limit the power of the government to make people illegal, to survey, to exclude those deemed illegal, to raid workplaces and homes, to detain and deport. The broader fight of having a kind of racial justice angle within an immigration approach to immigration or migrant rights must mean building larger constituencies committed to freedom of movement and rights to stay, and building the power of an anti-racist left committed to dismantling borders in the places where we all live, work and play. Okay, so a few questions which may be useful. That were just things I was thinking about reading over the blurb again, Zoe, that you sent over, and thinking about the questions that animate you inviting me and having this discussion. One thing which you actually alluded to in your introduction about working out where we're at is how effective can case law as a strategy be under this government, with Priti Patel's Home Sec, or rather, how can strategic litigation be combined with other struggles, other tactics in the struggle against authoritarianism? What I was thinking here is I imagine that we all probably fear that if we make progress in the courts, increasing the scope of human rights, for example, or winning an important case, then the government might respond by legislating the problem away, by closing the openings. And I was reading through history, you mentioned Shamima Begum, but the history of some of that case law around deprivation, and it seems to be that that's how it works. The government feels its power clipped by courts and then legislates the 2014 Immigration Act, being able to render someone stateless if it's assumed they can get nationality elsewhere or whatever it might be, or changes the rules. So, I mean, this is all to say we still have to try, and we have to try for individual clients and for overall improving the legal system. But it suggests the need also to build the political power of migrant rights groups, anti-racists, whether it's legal sector unions, so that the government does not feel so secure in its mandate, basically, to do all the things it's been doing, to send people to Napier or Penally, to process claims on ferries or in the South Atlantic. How do you build the force of the groups which protest and say, not in our name? And I think that would benefit strategic litigation in an obvious way. And therefore probably strategic litigation linked to those kinds of movements is the way forward for us all to think about the complementarity of social movements, broad constituencies, and clever legal work, basically. And this is not an anti-expert, only bottom-up grassroots stuff will do, but it's to say that we need both, and more fundamentally that the success of our fight depends ultimately on building that power more broadly. Another thought I had was, could we more proactively suggest another immigration system or immigration rules that would work for clients and human rights without reinvesting in the legitimacy of violent borders? So I'm thinking here of, I mean, we all know that the laws and rules are too complex, and that seems to be part of the strategy and how difficult they are for people to access justice. But I'm just thinking about whether groups, law firms, migrant sector groups, and maybe I've already done this, but could come up with a kind of more fundamental set of rights that could be backed by progressives in general of different stripes. So progressives from liberal progressive people within political parties, unions, but also right up to people more invested in radical migrant no borders politics, for example. And I know Liberty recently did their alternative coronavirus bill, the Protect Everyone bill, which was an attempt at something like that. This is how we could actually protect public health while protecting civil liberties. So could we do something that was not about rules and laws of entry and right to remain in deportation, so a more humane deportation system or a more humane detention system, not a set of reforms, but perhaps a set of basic fundamental principles or a charter or something, which would include access to justice, access to legal aid, law centres, expanded right to family and private life, the right of asylum, however you arrive, without a culture of disbelief in the Home Office, something proactive, which again could be backed by perhaps something to petition parliamentarians on, or the progressives in Labour, Greens, Lib Dems. I know Labour have their freedom group for freedom of movement, for example, who are up against it, I imagine, at the moment, but are trying. Or something as a resource to share with young activists, climate groups, people on the streets for BLM. And that's an important thing, right? You see a lot of people on the street last year, biggest mobilization of people for an anti-racist protest around police violence, an ongoing protest, and there will be more this weekend around the police crime sentencing bill. How do you make it easy for people coming through, young people, people broadly progressive, to make the connection with borders? Because I think it's become more immediate that you make that connection between racism and policing. But I don't know if we've quite made the jump, and I think it's a harder analytical and political jump about people who aren't necessarily citizens, to connecting that to a kind of anti-racist project broadly. Having more people outside Yarlswood detention centres, more people on the anti-racist side at Napier, those kinds of things, more people offering solidarity. I think that is a way that judges do start to think about scrutiny from a wider set of people on what kinds of decisions they might make and on the importance they should weight to what we might call racial justice or racial equality. So I'll leave it there. And sorry, I've got a bit of time.
No, it's fantastic. It's been a fantastic overview of the framework of your book. Thank you so much for giving such a powerful summary and your perspectives on looking forward to the future. I think as lawyers, we certainly know that that need for a sort of double track. You know, we do what we can within the law in terms of our clients' cases, but also know the unfairness of the laws that are applied and work proactively on legislation to the extent we can as sort of a marginalised interest group. And so know that kind of those wider aims kind of alongside what might be more achievable or strategically achievable within an individual case with the framework that we have. So thank you for that really thoughtful consideration of those two areas. Because I'm familiar with your book, I'm really keen to kind of put some, sorry, that's my door, texture on some of the things that you've talked about. One of the things you touched on just now is some of the cultural attitudes in the courtroom around the role of families and the role of fathers, the nuclear family, and the hope of being able to perhaps explode those concepts of family relationships to include networks, friendships, other types of social relationships. I wonder if you could talk a little more about that particular area of your book. I think because it's something we see as a kind of an area of possibility for developing the law, and so it would be really helpful to us if you could say a little bit more about that particular aspect.
Yeah, sure. Thanks for picking up on that. I mean, I suppose when I started the book, when I started going to Jamaica, I was thinking basically that people are being deported on the basis of criminality. So my intervention is to think about other ways to tell the story about how people end up in prison or with criminal records. If I'd been a lawyer, I probably would have known straight away that actually that is one coordinate, and the other one, you know, just simply in a proportionality thing, and the other one, which is the public interest thing that I was arguing against. The other thing is the right to family and private life. And that's, I mean, I suppose the other thing to say to a if there were more non-lawyers here, I think you have to spend a lot of time saying what actually is the legal process like, both bureaucratically with Home Office decision making, and then when you find yourself, if you're lucky enough to get a hearing in the tribunal, it's this very intense weighting of so many circumstances, which is, yeah, it's all pretty gross, I think, personally. Like, how do you evidence your relationships to people you care about? How tight are you with your siblings, with your mother, with your children? Have you really got evidence that you collect them from nursery? Where's a social, let's get a social worker report in, or a OASIS report, which are, the kind of the intellectual assumptions under all of the stuff within probationary things I find really disagreeable as well. But so if you think about the whole, and I'm still interested in this and thought about doing a follow-up project on the legal process, on turning a life into a case, on evidence, on what it means to live that experience, witness statements from children and friends, all of it. And I think that was the thing I was struck by, probably from doing expert reports at the same time as seeing some of the guys' own legal files, and wanted to kind of subject some of their legal files to analysis as well as what they'd said. And so the Danico chapter in particular, the Chris I threaded a bit in as well, because it became more important. But the Danico chapter, I was thinking, I've heard a story of family separation, of romance, of love, of parenting together, of something familiar about building your life with someone, and then that being destroyed by deportation power, and then wanting to compare that with Home Office, what the Home Office said in their decision letters. Basically, that was my approach to that chapter, and I think it is one that brings out the brutality of that system, to compare a human account of a relationship to the Home Office saying, you've hardly been in their life for very long, and all that stuff. So that was my way in, was to realize suddenly, actually, the reason people burnt their documents is not because they called them a criminal. It's actually because they said they were a shit dad. That's the thing they couldn't get through. They could do the repenting thing. I shouldn't have sold drugs, and I didn't. That was a bad decision. But the family stuff is the bit where they're trying to prove a positive and getting told that it's not enough. I think that's why I ended up focusing on family. And then, as you say, my analysis is to take from kind of feminist and queer critiques of the family, the idea that the family is not an innocent space of kind of reciprocal, equal relationships, but a hierarchically organized one, and one that is the norm of the nuclear family or whatever, has a history, and is subject to state policies. So that's the overall critique there. I think the thing about friendship is interesting because, my supervisor, Bridget Anderson, who also writes really well on these questions, once said to me, if you had a friendship visa, then you'd have no borders. And I think it's worth thinking about why that is and what it means to value other kinds of care and relating to one another and mutual support, which a lot of people need and rely on. And again, this is something that comes out of queer literature, queer critiques, the families we choose, the forms of kinship that people rely on when they're excluded from the nuclear family. And that can be true actually for young men hanging out in the park or on the street, or people who are looked after by the state. A lot of people who end up in prison are also likely to have very tight relationships with peers, which just aren't considered in the immigration system. So I thought that was worth saying to a broader group. I think a lot of people who read the book will have no idea that these kinds of assessments are made, and that there's something inherently unjust about the whole thing. There is also, I think, scope for lawyers, again, to then think about, the fact that your relationship with your adult parents can't be valued unless you perform a fundamental care role, the fact that siblings basically doesn't really matter unless you look after them. Everything comes down to, kind of fundamental, they won't be able to look after themselves without you, which is not really how that's not how I relate to people. I would survive if they went away. Most of us would, right? We'd survive, but we'd be devastated. And that's what deportation does. So there are ways, I guess, to try and value more and more the ways we need each other, and deeper critiques of the way the immigration system individualizes a person and strips them of all of that to judge them, as does the criminal system, rather than thinking, and the criminal system does it to deport people to prison, really, for long periods of time. The immigration does it to exile people from the country. But I think I think one of our best resources, and then, you know, the family life, expanding the power of family life can be useful, including friendship would be great. Having a more generous reading of partners, relationships and relationships with children would be, and best interest would be excellent. But all of that comes down to us saying, actually, we're not individuals who only are accountable to ourselves. We all are deeply invested in others. And if you deport me or imprison me, then you actually really, that punishment can't be just reduced to unduly harsh. It's a huge punishment. Yeah, I'll leave it there anyway. And also maybe relating to pets, as we can hear now, that could be one. Theresa May's cat thing, we could fight for.
Yeah, she'd love that. One of the things that you talk about in your book is the impact of deportation on those left behind, family and friends. In a way, as lawyers want, you know, if our clients are deported, you know, our relationship ends, but it also ends with their family here. And you also interviewed family members here. And I think one of the things that really struck me from your book was the impact on their sense of self and their sense of citizenship, having been witnesses to the process of deportation. And for me, that was really powerful, thinking about how the deportation process in itself produces inequality, and, you know, in terms of making people feel less secure in their citizenship and potentially other types of inequality. And so I wonder if you could say a little bit about that aspect of your work.
Yeah, I mean, I suppose again, I take a lot from my supervisor on this particular point, who wrote about fantasy citizenship and about the way in which immigration control tells us, serves a particular idea along her book, Us and Them, is basically saying immigration controls are as much about us as about them. And what she means is that the way in which the citizenry is defined, the way in which the nation is defined as a particular community of value, is done through the exclusion of particular kinds of migrants. And so the myth then is that what immigration controls do is they protect the interests of citizens, keep out the hordes, keep out the, you know, the whatever animalistic or water-based metaphor you want to use for migrants, and protect public services and protect basic protections and culture, whatever it is. But of course, immigration controls don't protect the rights of citizens, especially not the people who lived their lives with immigrants who are deported. So it's a kind of broader way of saying the exclusionary logic of immigration controls says that to protect citizens, we need to exclude migrants. But actually, you know, aggressive exclusion of migrants tends to go hand in hand with the, you know, decimation of the welfare state, the right to rent or the right to work. I mean, these aren't rights in most people's minds, but they become rights because apparently you have a right to work or a right to rent because an immigrant doesn't. All of which means there's a kind of mythology around what immigration controls do and how they defend the rights of citizens, but also this idea that there are immigrants over here and there are citizens over there. So the book, you know, I describe Britain as multi-status, which is to say people live their lives with people of different statuses, and that there are complicated hierarchies between different shades of citizen and non-citizen, all of which are how we need to understand racism. By different shades of non-citizen, I mean, of course, you know, people with indefinite leave, families where people have different statuses, people with temporary leave, people in the asylum system, people who are undocumented or underdocumented. And then the shades for citizens are, I mean, prisoners don't have citizenship rights, fundamental citizenship rights, for example. So if and a lot of the guys who you meet who've been deported or who you might meet who in prison or in detention know a lot of other people who are imprisoned, right? So people who basically are formally excluded from the labor market, pretty much. If you're black and you've got a record and you've got no qualifications, you can't really get a job. Or in many places. So you lack, the welfare state is punitive or doesn't include you, including housing and stuff. So social rights don't really exist. And you are heavily policed, denied the right to kind of freedom of association, to the presumption of innocence. And if you're incarcerated, of course, you're denied loads of fundamental rights. So there are shades of citizenship and non-citizenship, and racism is part of what determines those hierarchies within citizens and non-citizens. And so my book is trying to say, what does witnessing deportation do in that context? So what does it mean to be a young Black British person with friends from different nationalities, which is true for many in London, in Birmingham, in Manchester. For young people especially, right, it's increasingly the case that people are different statuses of young working class Black and brown people in particular. What does it mean to see a friend get deported? What does that mean for then all of that already unequal access to citizenship rights that you had, rights of security, dignity, of, you know, rights to political participation, rights to freedoms? What does all that do to witness someone be deported? And so there are many cases, there are a few cases I picked, you know, the young friend of a non-British Black friend of, you know, a Black young guy who also was heavily policed. What does it do to their sense? A partner who might be of any ethnicity, a partner's mother. There's different cases I pick, people who are more or less included in the British nation as citizens or as racialized people, and think about how, you know, deportation reveals that fundamental inequality among and between citizens. That's the point I'm trying to make, is to say, if we want to understand racism and immigration control, we might do well to think about people who fall in different places on this, access to rights, basically rights and freedoms. And we might then see connections between those defined as immigrants who are stealing your job and citizens who are being, you know, kicked out of their council home. You might begin to see those connections and build from them, which is ultimately the only real way, I think, that we're going to fight for something radically different rather than just tweak.
Yes, and I think one of the examples in your book was really compelling, as somebody you talk about people at those different levels of citizenship, of people who are one person who moved to a different area because of the fear that they might be caught up with the sort of same friendship group and get involved in crime and the risk to their citizenship, but also someone with British citizenship in a different case, fearful, having witnessed deportation, of being more insecure in their sense of belonging and citizenship in the UK, that fear of it being taken away at any time, even though, you know, with citizenship in their case, that not being an objective fear. So, you know, one of the conclusions I drew for your book is just how much this process entrenches that inequality into the future.
Exactly.
Very much aware that that, you know, any you know, change that we might try to do as lawyers is part of a wider process and campaign. And I think one of the sort of thinking behind this seminar is that perhaps, you know, there was a time now with the Windrush awareness where I think as lawyers we've been, you know, quite depressed about how hard it was to win deportation cases, but there now seems to be more of an awareness of what those kinds of impacts may be, both on the individual, their families, and the wider community. I think before bringing in Phil to kind of talk about some of perhaps, you know, how we might translate some of those big ideas and concepts into practical tools for our practice, just also encourage anyone to put any questions in the chat at this stage, and Phil, to invite you any questions yourself before we move on to your part of the session this afternoon.
Hi, I think I've just got a few thoughts, basically, which I don't know if it's a particularly coherent set of thoughts, but in some sense it's sort of drawing on where we are, where we might have been in terms of the case law, because I think there seem to have been some, there are certainly some moments in the development of case law which point to a sort of more positive movement and what we can actually do about all of that in terms of where we are now. Now, I think just building on what Luke was saying, I think there are fundamental issues with the Strasbourg case law, just in terms of I think there are perhaps two major issues. One is the way in which private and family life are very much separated out. Now, I think that the risk of that is that it really doesn't draw adequately into focus the real substance of what someone actually has by protected Article 8 life. So it's not simply a question of identifying what are the most significant family life type relationships. It's the whole web of connection and experience, friendship, etc., that people have, and in a variety of forms that Luke has highlighted. And I think it really is a problem with the Strasbourg case law, which seems very reluctant to move beyond family life arguments, which are based primarily on relationships between partners and the care given to minor children and the parent-child relationship. And really to interpret wider Article 8 family life cases solely really on the basis of a really significant level of dependency. Whereas Luke says that is not the reality of what Article 8 and about individual identity and about actual family life and what is important in our lives is really about. And I think there has to be some return to that and some push actually to try to bring that back into focus, however it's done. It is difficult, perhaps on a sort of practical level, actually using a wide range of witness statements. As I think Luke has also said, it's perhaps not necessarily an ideal approach to sort of fall back on the use of independent social work evidence or whatever it is, in the sense that we're almost sort of guilty of building a case that the court will regard as exceptional, which almost sort of runs contrary to the kind of general case we're trying to put. But I suppose it's one way of actually chipping away at these kinds of general arguments to at least get individual cases which reflect some of these things. Now, the other thing, just in terms of blind alleys and where we might have been, I think it's interesting to look back at the 1990s and the early parts of the sort of 2000s in terms of what was actually happening with the Strasbourg cases. Now, just very briefly to focus on two key cases, the case of Nasri in France and the case of Una, the obviously very well-known Grand Chamber decision in Una. And unfortunately, while say on very strong facts in the case of Nasri, which involved the deportation of someone who was deaf and dumb and had very profound difficulties and really was not going to be able to communicate with people around him outside his immediate circle if he was deported back to Algeria. There are some very interesting dissenting comments by judges who either dissented, although they agreed in the results that it was disproportionate to remove or deport someone back. There are very interesting comments by the Spanish judge, Judge Morenilla, who actually went as far really as saying that he thought that the deportation of, he looked at the position generally of people who had come as migrant workers. This was a particular context of the Nasri case. People coming from North Africa to France. And the points he was making were really about, if you accept that labour movement as a sort of matter of convenience to your national economy, then that came with obligations, and that the state was actually under an obligation to provide for social rehabilitation instead of sending people back. And I mean, I think that is a really important part of this whole argument about policy, really, and in terms of where we are. I think there probably are some of these things that there perhaps might be some sympathy for, looking at that in the context. And what he said also, I think very powerfully, was he talked about the concept of own country. And he said that is the country in which the person, the young migrant, was born in or has grown up in. So he really sort of tried to counter this argument. There was some notional own country when the person really hadn't either been born or really lived there. There's another partly dissenting judgment from the Swiss judge, Judge Wildhaber, and I think he made a couple of really interesting points. He thought that, and I think it's an interesting and important observation, I think he thought that it was artificial to separate out private and family life. That really to do proper justice to this and why all of this is actually important, you had to look at it in some more unified kind of way. Well, I suppose we have the position, at least in relation to integrated migrants, the sort of the Maslow type case where a young adult hasn't yet formed their own family unit. And that's sort of pushed away at the concept of private life and why it's important. And I think also there are some helpful domestic cases on that point, such as the case of CI Nigeria and the Court of Appeal here. But I think it really is important to actually retain focus, and actually just coming back to Luke's comments about why all of this actually is important. It's not about dependency or sort of what really in reality is a sort of fairly exceptional set of family circumstances. It's about what is really important in terms of being human, and what is really socially and culturally important. Now, the other case I just wanted to briefly refer to was the case of Una and the Netherlands. Now, there are powerful dissents. I mean, interestingly, one of the dissenting judges was Judge Costa, who's the French judge, who about a year after the Grand Chamber's judgment in Una became president of the European Court. And Una was decided around the time of the parliamentary resolution trying to bring into focus the position of settled migrants and suggesting they should have kind of quasi-national rights. And the dissenting judges were very clear that really the rights of settled migrants should be as close as possible to the rights accorded to nationals. They also made very powerful comments about how, and again, it's not an argument that has found particular force here, the idea that deportation is double punishment, that actually it's not preventive, it's punitive in nature. And I think one can well see in individual cases that really treatment of individuals may well simply be very punitive in terms of the way people are being treated. And I mean, I think again, as I think something that Luke referred to, we come back to these ideas of public policy. It's all very ethereal, the idea that the public interest requires deportation because it is helpful to actually maintain prevention, to show deterrence, to maintain public confidence in the immigration or criminal justice systems, or whatever good is claimed. But we never actually see empirical based evidence to actually justify those claims. And I think it would be very interesting really to look at actually doing research on these issues, to actually try and unpick the basis of the policy arguments about all of this. And of course, actually, again, as Luke was touching on, the idea actually that these policy imperatives, particularly when we live in very mixed communities and people really live with people with all sorts of mixed statuses, it really unravels a lot of this, and it's extremely socially divisive and extremely socially damaging to the community. And I think, again, these are things that would be really interesting to look at. Now, another thought, and again, I don't know particularly where it leads, but I think it's perhaps just helpful sometimes to look back at the sort of pre-Article 8 paradigm and actually see that, in a sense, Article 8, perhaps in some senses counterintuitively, has actually sort of justified harsh decision-making. When you actually look back to the pre-2012 framework for deportation, the old rules, paragraph, I think it was 364 in the immigration rules, it talked about the public interest being balanced against compassionate circumstances. Now, it required a decision maker to look at all of the circumstances that were known in the individual case, such as age, length of residence, strength of connection, personal history, character, domestic circumstances, and any compassionate circumstances. So those were sort of powerful considerations which really tended, rather than looking at anything else, they tended really to focus on the individual's standing in a very factually nuanced way within this country, which is a really important focus to maintain. Now, the other thing I think is interesting, there's a very old House of Lords case, a case called Bakhtar Singh. Now, Bakhtar Singh was someone who arrived in the UK as a priest and a musician. He overstayed, so at that time he was liable to deportation. And what really came into focus here was a lot of representations that were made by individuals and organisations about his value as a musician, and also sort of performing at charity events to the community. And the leading judgment Lord Bridge in that case focused very widely on the possible significance of an individual within the community, and tried to sort of identify sort of concrete examples where a person's value in an individual business or in a local community, because they were a social worker or whatever they were, was important. And he used those to simply illustrate how one actually could move in to look at the very individual significance, or actually sort of maintain a wider focus in terms of general value to society. That case was picked up by the Court of Appeal and analysed, not entirely helpfully, in a case called UE Nigeria in 2012. And it looked at the individual value of a person and how that actually counted in the deportation balance. The more helpful of the two substantive judgments delivered, the judgment by Lord Justice Keane, focused on how the position might be relevant in looking at the public interest, and also on the other side of the balance. I mean, Lord Justice Richards was more keen to sort of limit the value and the significance to the particular circumstances of that individual, attenuated very closely to the balancing exercise. But I think what it does show, those kinds of discussions, while certainly in that case, the suggestion is that probably the value of the individual to the community might not necessarily, unless it was exceptionally strong, count strongly in the balancing exercise or in the analysis of the public interest. I mean, so far as I'm aware, there haven't been other attempts really to try to bring in other elements of the public interest. I mean, certainly in the 80s case of Bhatia Singh, the House of Lords, because of the wide discretion indicated by the wording of the rule at that time, any relevant circumstances, they were certainly very open to actually looking at the concept of public interest in balancing exercises. And it's something I sort of throw open, whether actually there are strategies that we can look at to actually see whether we're seeking to bring this in on the basis that it's relevant to the public interest element in the balancing exercise, or whether we can bring it in as another part of the exceptional circumstances beyond the kind of exceptions identified in the rules and the statute as being where you will win deportation. How we can bring in those kinds of things as Luke has discussed. Now, the only other thing that I want to just sort of briefly highlight, and I'm not sure I'm going to say a great deal about it, because I think the cases now are pretty well known, just to sort of draw attention to the possibility that there is some, at least, progressive movement possible within the domestic case law. I think identified perhaps in two important decisions, the case of CI Nigeria from 2019, which is one of the best and most progressive judgments from the Court of Appeal, at least in terms of interpreting, coming back to this idea about what family or private life is really about. It's a sort of really strong paradigm statement about the importance of ties, relationships with friends and relatives, being involved in employment or other paid or unpaid work, participation in community activities, a whole range of things that really form the important elements of Article 8 life. And a strong pushback against a sort of really restrictive view on people not being socially or culturally integrated simply by the fact of having committed offences, where there was that suggestion simply by implication that because you had committed offences, you weren't socially or culturally integrated. And I think it's helpful just in terms of, again, suggesting that it may well be very naive to assume that simply because someone nominally comes from another place, having spent the majority of their life in the UK and having left, often with their families, the place in which it's intended to deport very early, that really one can speak of a connection such that integration is going to be possible, and somehow sort of placing the onus on the the person being deported to show that it has been broken, which may really be putting it in the wrong sense, given the obvious common sense inferences that you should really properly draw from the facts if you thought about them. Which certainly, I mean, certainly in the individual case, using drawing on Luke's work, I found extremely helpful in sort of showing the implications of someone who had been out of Jamaica for sort of 40, 50 years, being deported back. And then the other thing, really, just in terms of the rather unhelpful terminology imported from some of the Strasbourg cases, concepts such as undue harshness, which as a term, and taken literally, would be almost probably impossible to actually really give any proper meaning to. And the helpful cases really rolling back from rather sort of critical commentary of what Lord Carnwath was saying in KO Nigeria, the cases that followed HA Iraq, to simply suggest that exceptionality and that one couldn't look at a sort of the effect on a paradigm child, that you had to look very closely at the effect on the individual child, and that when we talked about what was exceptional in terms of effect and undue harshness, it wasn't necessarily a particularly high threshold test. It was simply looking at a significant impact really on that particular child or partner. And so I think there are perhaps some encouraging signs, at least with some of the more thoughtful cases from the Court of Appeal. I mean, having moved away from a sort of tendency to sort of fairly routinely uphold the Secretary of State in deportation cases. I mean, it may simply be that they're trying to set down a marker because they've just had such a large caseload that they want to sort of at least moderate some of the harshness. So, I mean, I don't know where really all of that, by way of sort of a few random comments, actually take us, but perhaps it does take us to focus on the first thing about the content of private and family life that Luke has very much highlighted, and just to actually look how strategically we might, within the rules that we have, seek to actually open up discussions about what policy really means, what the public interest actually means. That it may be much more faceted than is being interpreted or said by the Home Office. But I suspect really that's going to really will be something, if it's going to be an argument that we're going to try to have, that will require sort of fairly strong empirical basis in sort of research and work with lawyers and academics and people in the community to try to sort of pull some of that together. Thank you very much.
Thank you so much. That's been so very helpful. I think I'd perhaps just add to the discussion of the sort of recent helpful line of cases to flag up KB Nigeria, the most recent of that line of three. So you had HA Iraq, which set the scene, and then David Lima in this chambers with the very helpful case of AA Nigeria, in which there was that very helpful discussion that that KO Nigeria doesn't set some objective measurable standard of harshness that's acceptable, and that and it's dangerous to look for some ordinary level of harshness, and says there's no reason in principle why cases of undue hardship may not occur quite commonly, and how a child will be affected by a parent's deportation will depend on a range of circumstances. I thought KB Nigeria that followed was interesting because again, it's the third case in that line that's very helpful. But what the Court of Appeal endorsed was the first tier tribunal's decision that looked at quite a range of factors in a wide-ranging Article 8 proportionality assessment. So things that the first tier took into account that the Court of Appeal accepted were relevant were that the independent social work report that children would face in that case significant trauma if the parent was removed. But also accepted that it was relevant that the children's mother and former partner of the appellant had caring responsibilities for the grandmother, and so would have less time be taken away from the children without the support of the appellant. The appellant had also established a business, and the first tier tribunal judge accepted that they were a role model for their children, and that the Court of Appeal, the Home Office, having challenged the first tier as this being irrelevant to their assessment, found that this was a legitimate consideration that may contribute to the deportation having unduly harsh consequences for the children, and also commented on future financial provision itself being directly relevant to the welfare of the children. And so you have the Court of Appeal agreeing with quite a wide-ranging assessment, and so it seems to me that that we can also identify other factors relevant to the Article 8 proportionality exercise. So things like empirical evidence around the social research on what we know about the impact of single parenthood in the mix with all the other factors that may exist in the individual case. And so it seems that there are other factors that could be brought in that provide evidence of the kind of wider economic and racial equality impacts of separation, and the entrenchment of those inequalities, in addition to the kinds of factors that we're more accustomed to arguing in individual cases. And just in response to a comment, yes, that was KB Jamaica. I probably said a whole list of cases all at once, so apologies if that wasn't clear. So yes, it does seem that although we're at kind of quite early stages, there are things that we could begin to bring into our practice to try and make visible some of those wider impacts that are more difficult to identify perhaps in an individual case, and certainly can completely take the point around the difficulties of relying on expert evidence around things as normal as family networks and things, and Phil's point about, well, kind of perhaps starting there and making those cases before it becoming more widely accepted. It certainly flags to us the need to identify those areas of evidence. So whether it's independent social workers from a wider pool to reach a kind of wider experience, as well as community networks of to approach for that more grassroots expert evidence, as well as the kind of academic empirical research that that will help us identify those more kind of wider impacts and the entrenchment of inequality. And so that's something for all of us in terms of thinking about how we go about evidencing these types of issues. I think that's all I was going to add. I've gone on. Is there anything that you would perhaps draw out, Luke, from Phil's discussion of things where you might input some suggestions? I noticed that you've flagged a particular case in the chat, and just again, because people with the recording don't necessarily see the chat, it'd be really helpful if you could perhaps expand a little on that.
Yeah, I mean, I really enjoyed that. Thanks, Phil. And there are a few. I mean, I was taking notes, and there are a few things to say. But I suppose the thing I put in the comments is in relation to, I suppose, the point on public interest arguments, and this is also what one of the Q&A questions refers to. I suppose I was just thinking, and again, it might not be the most useful for those doing the litigating, but I do think it's important that some campaigns gather more energy than all of the invisible cases that no one knows about. So we'll know deport cases wise the two twins who are facing deportation to different countries who were born in London, Darrell and Darren, I can't remember their surname. But a lot of people know about that. Asime Brown, who faced deportation, his mum was, very coherent and brave and got involved in a campaign kind of, and, BLM UK backed that. And there was One Extra Talks had an event on deportation in which I was invited on. I mean, that doesn't happen all the time. So those kinds of cases are really interesting because they are often, it's hard to predict where they'll emerge, but we need organizational forms that can support them, give strategies, think about how to make them big without making them, this actual person's a really good migrant, and I think a wider awareness of racist discrimination in the criminal justice system means that we can handle a lot more cases in the public realm than the kind of cuddly genuine refugee victim of persecution line that was what I became frustrated with when I first started writing on foreign offenders. I felt like the reports that I think it was LGSM, is that what they were called, London Detainee Support Group or something, did another, they sort of wouldn't mention that all the people who were indefinitely detained were foreign offenders, but I think now they'd and I'm often in conversation with Beard about their work with on families, on prisons. So I think there's a space there to make a public campaign gather energy, which says, look at how these injustices are connected. You've got someone who's excluded from school, someone who's neurodiverse, someone who's faced police harassment, and someone whose family, whose mum, came as a labour migrant or whatever it might be that Phil was alluding to as well in some of the case law that never came to fruition. To think about this place and about therefore deservingness, contribution, either trying to explode them ideally, but in the meanwhile also just opening them out. And I think public interest is one of those. So the case I mentioned is, I think he's called Sakchai Macau. I'm probably saying his name terribly. Just a Thai national who grew up in the UK from quite a young age, but in the Shetland Islands, and successfully managed to appeal his deport case in 2006. This is because when I analysed foreign offenders, the foreign national prisoner crisis of 2006, I looked at some of the cases they used, and they focused on, killers, rapists, paedophiles. That's their line over and over again. And particularly that guy who was Somali national, maybe, who was involved in a case where a female police officer died. Then he escaped under cover of a niqab, and so that became obviously the most supreme sign of where the country had gone awry. But so these kinds of cases, there were a few where people won though, and I think his was interesting because of the strength of a local campaign, because of the strength of a Shetlander identity over a national one, and I think that can happen with Bromies or Scousers or Londoners or whatever, or rural community. It doesn't matter, but the point is that there's a generic national claim to public interest, which can, I think, be counterweighted in political campaigns by effective communications around what this person is and who supports them. So Sean's question, who me and Sean have interacted before, is about how there is no investigation by the courts into what public interest involves. The courts merely take as read that the public interest requires deportation because the SSHD says so. But the public interest must comprise more than the negatives than the Home Office says it does. Must comprise the positive issues. I think that's really interesting, and I suppose we're arguing for the strength of family life. One way is to also hit the public interest line, and I think that's really, really interesting. And I suppose it would be about defining different kinds of publics. I think similar arguments can actually be made in the context of radical criminal justice reform or abolition that are gaining ground now, because the public interest is what defines the punishment, the punitive approach of the criminal justice system too. But which public? I mean, what good does it do to lock up people from particular communities? Who is actually served? What do we mean by justice? And I think that can be asked too, perhaps with a public interest case, and more broadly of the immigration system. Deserving to who, contributing to what? All of those questions are really worth asking. And if we're gonna really change the system, not just small gains, I think it does rely on exploding out.
I mean, I think it's very difficult. I mean, those things are difficult to attack simply because of the case law and the sort of the statutory and rules-based presumptions about the public interest. But I mean, certainly, there are ways of sort of trying to chip away at all of this and open up a debate about all of this.
And certainly the public interest can include the need to promote racial equality. And the big takeaway from your book for me was just how these processes operate to entrench inequality in themselves, and that if you're looking at kind of the wider duties around promoting community cohesion, race equality, then that has to also be factored into the public interest.
Yeah, definitely. I mean, the only question I have back to you, Phyllis, is because you've worked in kind of litigation for a long time. Do you feel like, what are the limits of the chipping away method? And I'm not saying this as a kind of it can't work, but I'm thinking, do things sometimes happen? Like, do you have experience of things happening quickly, either getting worse very quickly or getting better very quickly? Because obviously we have, New Labour, 9/11, all of those things, and then we have, Windrush. If for people campaigning to close detention centres and stop deportations, Windrush and COVID have been the things that have actually reduced those. So I'm just wondering how we think about the time frame we're working at, because I mean, also I think it's perfectly legit to chip away because it's also a profession. But I'm just thinking about the effectiveness of how we build for a kind of jump. I mean,
I think it's very difficult to say. I think one way of looking at it is to say that things remain bad for a very long time. And sort of for varying reasons. I mean, I think it's just it is really difficult, isn't it, to sort of find some strategy, because I think very often the most effective way of trying to deal with any of this is to deal with the individual case.
Yep.
And the success you have, of course, is that you produce a sort of factually solid decision which isn't appealed up. I mean, I think it's interesting, actually, that there are some things which I think happen. I mean, it's always a very unequal battle where the litigant on the other side is always the same, and they can pick and choose which cases go up to the higher courts. And I mean, I don't know what other people will think about this, but my impression, certainly from a couple of things I had, which were going to go up into the Court of Appeal, was the fact that they had lost on this series of sort of undue harshness cases, made them a bit wary about the cases they were going to take forward in case they lost some more. And I think they perhaps have got to a point where they are slightly wary now. They don't sort of see the Court of Appeal as simply rubber stamping their decisions. There has been a sort of shift. I mean, I think, it's difficult, isn't it? I mean, I think a lot of people simply don't understand the reality of deportation, the incredibly low thresholds, that you can be someone who's been here all of your life, or virtually all of your life, with indefinite leave to remain, get 12 months, or get less, and be categorized as sort of persistent offender, a sort of petty but persistent offender.
Yep.
And be up for deportation.
Yeah, I know someone who was here from the age of 4 and had ILR and got deported under persistent offender for a non-custodial suspended sentence. I mean, people don't know that. That's why I do think there's ways of building people who do know that, and I think this is what the Seymour Brown and all the other cases do, is they make people who collectively could have some power kind of stand up and say, wow, this is something we should know about and make noise about. And I don't know how strong or how weak this government are on these questions. It's hard to measure them. They know the kind of mileage in a culture wars style, send the Navy in for the boats, lock them all up thing. But judges, I don't know. There's different. Yeah. Also, we have to think about the next government and the one after that, and what becomes possible, because for quite a long time it's been possible for the left or centre party to be pretty terrible on all of these questions, and that that's also a question about time frame, how we're thinking.
I mean, unfortunately, Labour in power have not been great on this.
No.
So exactly, that's the reality.
But it's an important message to us about avoiding the kind of good migrant, bad migrant dialectic, because we see that then being imported into other things. So, a lot of the discussion of the new immigration plan is around importing these notions of criminality and bad migrant into justifying even harsher approaches to refugees and more broadly. And so, again, the importance of campaigns more widely. I think one of the things that comes out in your book is just how the immigration system produces the kind of precarity that in the early days, and how that, alongside other types of difficult circumstances, causes disadvantage. And one of the comments in the chat raised states that there are a number of allied issues, and particularly the cases of young people who were in care and could have been registered as British, and it didn't happen for various reasons, but through social services, and so then they've missed up the opportunity to gain citizenship and then become vulnerable to deportation. So again, very much in keeping with some of the themes of your book around that reproduction of precarity and difficulty.
Yeah. I mean, I met someone.
Sorry, and just there's a follow-up from the same person and stating that a lack of awareness of criminal law judges, that if they sentence for 12 months, then the automatic deportation provisions kick in, and you know, many may well choose instead to sentence for 11 and a half or lower if they had that full awareness of actually the full range of punishment that would be headed towards that person.
That's really interesting. I look out for that program. Shout out to Jackie. I know Jackie's done a load of these kinds of cases around Windrush and in response to charters. So yeah, I've seen that stuff, and I've noted that as an interesting thing around Brexit, actually, around when this becomes real. I know that Coram and other people, there was an article in the Guardian today again about those people in the care system and how they're going to struggle, and, you know, trying to connect also Brexit to a wider anti-racist lens to kind of, I mean, the big mobilizations, BLM, XR, and the kind of Remainer protests feel like very different constituencies. I think there's some work that goes into saying that those are actually connected, that a political party and a mandate for get Brexit done, for British sovereignty, for temporary rightless labour from anywhere, for illegalizing people is connected to aggressive policing and to that kind of, is appealing to those kinds of constituencies and racist law and order politics, basically. So I do think there's a lot of work to do to say, I mean, I think people have tried by saying this could be the new Windrush, which is just, I mean, fine, it's a headline. I don't know if it's the most helpful, but yeah, I think we're going to see that with young EU migrants who are vulnerable. And I met one guy who actually the social services in the West Midlands did try and help him get regularised, and he was able to stay and now has a child in the UK, heavily criminalised young person who was facing deportation to the DRC, and someone made the decision to fund his work out, how to fund his application and everything. And I think there's a lot of work that needs to go into that, both in relation to the Brexit situation, but just more generally for people to know about basically multi-status undocumented children and how you can try and give them a better chance of building a life.
Absolutely. We're coming up to time. I just wonder if there's anything that either you, Luke, or Phil would like to kind of add as a sort of ending comment.
I mean, I don't really have any comments to make other than just to sort of say a massive thank you to Luke. And I think it's really, I mean, I think the only thing about this is that, I mean, it's a very tentative start, but it would be nice to actually sort of take this forward and to actually try and sort of brainstorm in more concrete ways just how some of the challenges might be taken forward. I mean, it seems that there are probably a whole range of things, campaigning, legal strategies, trying to work within the system to actually sort of generate more positive case law, and to undermine some of the problems with the sort of existing kind of paradigm and analysis, which would be great. So I think that is a really interesting thing to try to sort of kick off.
Yeah, no, I think that's really important, and I think it's also thinking about the strategic weak points around policy as well as, you know, winning some cases, around whether there's ways to win some ground, I suppose, for deport cases more broadly by changing some policies. But it just feels difficult with the cartoonishly evil Priti Patel at the helm. I mean, I know we've had a whole suite of evil home sex, but it feels difficult. I'm not sure about how to strategize, but still, no, I think it's important, and I'd be happy to talk more about what I've gained from both doing the work and also doing expert reports, which someone has messaged me about. I'll reply to them.
Oh, Brilliant. Yeah, certainly that academic practitioner dialogue is so helpful, and just for everyone participating, you know, we're really keen to work with people around these issues of sort of making those more visible and bringing these these issues out. So very keen to kind of keep working on that. I really want to thank both our speakers, but particularly Dr. Dinarunya for joining with us today to share his insights and perspectives from his research. I would really recommend his book, and it has been a really insightful and thought-provoking read. The link to the book is in the seminar invitation that's currently on our website. We've updated the link to include the link to Manchester University Press, because they have a deal on at the moment, which is great, of the book's half price, which makes it, it's already very affordable, but even more affordable and accessible. And it's a really good read as well, because it takes it talks us through the stories of the four people profiled and their families, and walks through that process for them, as well as really fascinating insights. So today was a brief snapshot, and there's very much more to read about in the book. So thank you so much for joining us, and thank you also, Phil, for joining us too, and to everyone.
Well, thank you very much, Zoe. That was great.
Yeah, thanks so much for organising it.
Yes,
those who organised it, both Zoe and
yeah.
Oh, so
Thank you both very much,
everyone, for attending. I just want to remind everyone that the webinar will be available on our website afterwards for any colleagues who missed it, and to thank you once again.
Thanks everyone.
Thanks very much.
Get out into the sun if you can.
Yeah, that's where you look like you are already.
I couldn't even bear to do the meeting out of it, so yeah, I don't know how the rest of you survived. But yeah, thanks so much, and we'll speak soon.